Hi everyone, welcome to the Latte Lounge for one of our regular expert Facebook Lives. We've got a fantastic guest today who was Boris Johnson's divorce lawyer, and he's going to be talking about navigating the divorce process. We're going to be here for about half an hour, ending with some frequently asked questions in our community. Obviously, please don't forget to follow us on Instagram at Lounge the Latte, Twitter at lounge_latte, our fabulous Facebook group, the Latte Lounge, and also please head over to our website, lattelounge.co. You'll find our special guests guide to the divorce process and lots of other midlife resources. So when I looked in my calendar to plan our content for this month, I noticed that January the 4th and January the 18th were sadly dubbed Divorce Day and Blue Monday. Usually this is because relationships can often reach breaking point during the Christmas period, and the weather's cold and miserable, kids are at home, and there's all sorts of pressures on everyone. However, I think, after the year that we've all had, and from all the messages we've had from women on our group, it seems that it's not so much about January, but about 2020 and the effects of this pandemic on all the lockdowns that have brought, sadly, many relationships to breaking point. So really, that's why I thought it'd be exceptionally helpful for any women on our group who sadly are finding themselves in this situation, to talk to an expert who can give some sound advice on how to navigate the divorce process when a relationship breaks down. So I'm delighted to welcome and introduce you all to Neil Russell. Hi, Neil.
Good morning. Well, good afternoon to you, and thank you so much for having me on your group. I'm privileged to take part, and thank you.
Oh, lovely. Well, we're delighted to have you here. And I'm going to give you all a little bit of intro into Neil before we kick off. So Neil is actually recognised in Legal 500 as being one of the go-to lawyers in the London matrimonial world. And he's a partner at Seddons. Neil advises on all aspects of relationship breakdown, including divorce, children and families, and finances. His clients come from all walks of life, from stay-at-home parents to captains of industry, high-profile celebrities and owners of family businesses. Neil deals with the most straightforward to the most complicated cases involving trusts and international issues. And Neil has extensive expertise, I should say, in advising on prenuptial agreements and cohabitation agreements. He's a member of Resolution and pioneer of divorce funding. Neil is known for his pragmatic approach and respected for his experience and ability. He advises clients on all aspects of the process and assists with ways to deal with the costs involved, using the law to unlock and protect clients' financial interests. In this, he endorses the words of Lord Justice Thorpe, where there is everything to fight for and nothing to fight with. When dealing with children-related matters, Neil regards the children as his invisible clients. His aim is to protect their future through his advice, steering clients towards an outcome that leaves the family best placed to move forward following the breakdown of a relationship. And Neil is also a family law commentator, and many of you will know him or recognise his voice as he regularly appears on LBC Radio on the Family Legal Hour. So, wow, that's a very big introduction, very impressive. And again, thank you, Neil, for coming on today. So look, I want to kick off, obviously coming to the conclusion that marriage is over and deciding that divorce is possibly the best option is never easy. So perhaps you could kick off and explain the process for anyone who's watching today.
Yes, you firstly said that it is a massive decision for anyone who's thinking about whether they want a divorce. And a prelude before we actually get to issuing a petition, clients sometimes want advice, and people should take advice before even making a decision whether or not they want to end the divorce, because many people can't even make that decision until they've got some advice. So I call that first meeting quite often an information gathering meeting, to help you to obtain the advice you need to process the consequences if you decide to get divorced. Right. Now, before I go into any process, I'm a lawyer, and I have to think for myself and also for the Latte Lounge. What we must say is that any advice given today is generic. It's not specific to any listener or subsequent viewer or any particular question that we may answer. It is just generic advice and cannot be relied upon for legal purposes. If you want advice, then you should otherwise research it or get a lawyer to give you specific advice, and then their advice is under the terms of their letter of engagement. So I just need to clarify that for anyone who's listening in now or in the future. Sure. So in terms of the process, we are still stuck until autumn, or so around autumn of this year, 2021, with some people describe it as fault-based divorce. In October, November of this year, we should have the new divorce and separation bill, which will mean we won't have to cite one of the factors that we now have to rely upon in order to start with the divorce process. So at the moment, because many people won't necessarily want to wait until the autumn, if you want a divorce, you get divorced on the sole ground that the marriage has irretrievably broken down. That is proved by one of 5 facts: adultery, unreasonable behaviour, 2 years separation, 2 years desertion, or 5 years living apart. Now, for many people, adultery isn't applicable, and people have not lived apart for 2 years or 5 years. So unreasonable behaviour is what is often relied upon. May I emphasise that we don't need to use a petition to character assassinate the respondent party. We should generally be looking to use the petition simply to end the divorce, so end the marriage, rather than start a war with the respondent party. Divorce is difficult. It's difficult because of the uncertainty, and for many stay-at-home parents, the vulnerability. What we need to do is try and make things as amicable as possible. Mm-hmm. So when a petition is going to be issued, generally, if there are lawyers involved, we try and get the particulars, i.e. the fact that we're going to rely upon, and if it's behaviour, the particulars of behaviour agreed before issue. So that takes some of the conflict out of it. Then a petition nowadays, helpfully, because we were caught up in a huge delays at the court because of the pandemic, we're now issuing online. And very simply, a petition is issued or filed online. The respondent party then receives the papers, and they have to file what is known as an acknowledgement of service. And then once the petitioner receives the acknowledgement of service, they then apply for the decree nisi. Importantly, you're not divorced until the decree absolute, and we should not generally have a decree absolute until the financial matters are resolved. It's really important to get your finances sorted before you get the decree absolute.
Can I just ask you on that note, yes. Neil, sorry to interrupt, is there a cost involved with filing a petition?
Yes, thank you. There's a cost of £550 for the court fee.
Wow, okay.
The divorce process is simply an administrative process, so it doesn't require any attendance at court, it's just the forms.
Okay.
So you're only divorced when the decree absolute has taken place, and there's the million-dollar question, how long does it take? Yeah. If I could give a definitive answer to that, I'd be delighted. You can looking around 3 to 6 months, probably later, closer to the 6 months, but that would generally be delayed because on another track, we will have the financial matters being dealt with.
Mm-hmm. Okay, so the decree. So you start with talk us through the order. So we filing for divorce.
We start with a divorce petition.
Yeah, petition. Yeah. File
it at court. The court then sends out to the respondent party the petition, together with what's known as an acknowledgement of service, which mm-hmm. is just a box form filling process where the respondent accepts that the information contained in the petition is accurate, and they indicate whether they are going to defend the petition or allow the petition to proceed. And then when they send that back, generally 99.9% of divorces, that's not an exaggerated figure, I've been doing this about 32 years, and I have only experienced, I think, 1 or 2 contested divorces. There was a very famous one of Owen, Mr. and Mrs. Owen, that people may have read about in the newspapers. That's because those contested divorces are rare. So they're generally not contested, although there might be toing and froing in more difficult cases at the beginning. So the decree absolute will be pronounced and then you're divorced.
And so how does it work in terms of what women are entitled to and when? You know, obviously.
Right. So that's, you're talking now about the finances.
Yeah.
The finances are a different aspect. The starting point since the year 2000, and a case of white and white, is there should be equality. We should put all the assets into the pot and then divide them equally. That's the starting point. We then go back to the 1973 matrimonial statute and section 25, which are the guidelines that the court takes into account in determining whether or not the assets should be divided equally. And the first consideration given is to the welfare of any minor children of the family.
Mm-hmm.
We then look at the income, the earning capacity, the property and any other financial resources which either party has or is likely to have in the foreseeable future. And in terms of earning capacity, it's not just what you are actually earning, but what the court may think you could reasonably earn. So a stay-at-home parent may be expected to get a part-time job. The working parent may not be maximising their income. Some husbands may threaten, say, I'm going to give up my big job in the city and become a teacher. So they're giving up £200,000-300,000 plus a year incomes and becoming a teacher. The court would expect them to be able to continue earning at the higher rate. Mm-hmm. So that's the earning capacity which the court thinks is reasonable. The court will look at the parties' financial needs and obligations and responsibilities. They'll also take into account the standard of living that the parties have enjoyed. Now, we have to recognise that standard of living is not necessarily achievable in the same way going forward if there are two homes to provide for, because you've got two lots of expenses. We look at the length of the marriage, the age of the parties. We also look at the health of the parties, because that may affect what they can do by way of income, what they need by way of capital resources. Mm-hmm. And we look at the contributions which each party have made, and that's not just the financial contribution. The stay-at-home contribution by way of looking after the home and caring for the children is regarded as valuable as the income-earning spouse. So I get all too often mothers who have done a brilliant job, a magnificent job, which is much harder often than going out to earn an income. Absolutely. Looking after the home, bringing up the children, attending the dinners that their husbands have asked them to go to, be on standby whenever required, and multitasked and done everything. And then they get told, because they come and see me and they're really worried about it, he says, I'm not entitled to very much because he's earned all the money. Yeah. I can dispel that concern and say there is no need to worry in that respect. The court regards the contribution, looking after the home, bringing up the children, as valuable as any other contribution that may be made. Now, the next one is conduct. The courts are generally not concerned about how people have behaved. Having an affair, adultery is not conduct that's relevant, that penalises one person or compensates someone else in relation to the finances. Conduct's only relevant if, in the words of the statute, if it's inexorable to disregard, and that means gross and obvious. It's conduct that has had an impact on the finances, it's had an impact on someone's well-being. It's so obvious that you can't ignore it, that it needs to be taken into account. And it's rare that conduct is applicable. And then lastly, we look at things that you may lose as a consequence of a breakdown of the marriage, and that is pensions. Pensions are an asset just like any other asset on the balance sheet. They need to be taken into account. Right. One of the things I started by saying is equality unless there's good reason to depart. When we've got very big money cases, quite often when we share the assets equally, that provides enough for housing for both parties. It may provide for there to be a clean break to capitalise the income. So what claims may a party have? There's the capital claims, and the starting point for that is often housing. So if we're taking mums and children, mum and children need to be housed. And as I said, the first consideration is the welfare of any minor children of the family. So mum's needs may be greater than dad's. And because that's so, it may mean there's a departure in equality to provide mum with more of the assets in a smaller money case, because she needs more assets to pay for her housing and to assist the children's home life. Mm-hmm. So that's important. The other thing is, when we were looking at, in terms of financial resources, is mortgage capacity. A stay-at-home mum, or a mum at home not working all the hours in the workplace, may only have a limited income which only provides for a limited mortgage capacity. Whereas the person who's going out to work, who's earning a big income, has a big mortgage capacity. So that can be taken into account as well. So, I mean, there are so many permutations. I'm trying to keep it simple for the moment. I'm happy to expand on it, but the starting point then is housing. You may get housing if you need it, because you've got to house the children as well. And also your mortgage capacity may not necessarily be as great. Then there are other areas where you will need financial assistance. And that's with spousal maintenance. That's the maintenance that's paid to you for yourself. Mm-hmm. There is not a definitive calculation for that. That is dependent on each case in relation to your expenditure schedule. So your lawyer will generally go through with you what your items of expenditure are, where you buy your food, where you buy your clothes, do you shop in Joseph or, some of the other more expensive shops, or do you go to Topshop and Zara? I hope I'm not offending anyone with these points, but it's a lifestyle, it's an enjoyment. Some people shopping in M&S, some are in Morrison's. We look at trying to attain, so the higher the standard of living you had, the more we will be looking to get for your maintenance, because that's what you've enjoyed. The holidays that you've had, the standard of living. So that's your spousal maintenance. And then there's another element of maintenance, and that's called child maintenance. Child maintenance is generally dealt with by the Child Support Agency or the Child Maintenance Service. We used to call it the Child Shambolic Agency. And they have an arithmetical formula to calculate what the child maintenance should be. And keeping it simple, it's for one child, it's 12% of the paying party's gross income. For two children, it's 16% of their gross income. And for 3 or more children, it's 19% of their gross income. There are limits and caps, but I'm trying to keep it simple as we'll run out of time, and there's lots of questions, I imagine, other things we want to cover. There is a discount that applies as well for the number of nights that the children may stay with the other parent. So if they stay 2 nights a week, there may be a 2/7 reduction.
Can I just interject very quickly? What do you class as a minor? Is it under 18?
Yeah, generally we're talking about children under 18, yes.
Okay, but, and I mean, I know that it's on, a lot of people have already asked this in advance, but what about kids who are still in education, i.e., at university, and they're not earning themselves and they still need to live at home? Are they still considered a child?
Yes, they are in terms of financial dependency, because many of the times when we're negotiating and settling cases, we're looking in terms of the child maintenance, trying to keep that child maintenance going until the children finish at least their first degree. So we call it tertiary education, first degree. Mm-hmm. Sometimes those degrees are 3 years, sometimes they're 4 years, and if they're in medicine, then they're forever. So yes, we would be looking to keep that maintenance going whilst children are at university. And if the child is living away from home, then quite often the father will say, or the other parent will say, then I should be paying some of that maintenance directly to the child. And we start at a negotiation of 50-50, and sometimes then it's 1/3, 2/3. It depends on very much the circumstances of the case.
Sure.
But, a mum's going to she's going to still need to maintain the house. She's still got the bedroom to keep, and the expenses of keeping that larger house for when the children come back from their holidays. Mm-hmm. Sorry, come back for their holidays from university.
Sure. Okay, look, I mean, obviously there's masses to talk about.
So that deals with...
Sorry, go on.
Now, I was just going to say, so that I've tried to be as succinct as possible, but more than happy to amplify on anything. So we've looked at capital. Now, capital doesn't just mean housing. you know, if your husband is worth several £1 million or more, or even if he's worth less, it doesn't mean your needs are limited only to your housing. If there's a big pot to share, then you'll share in it. So not only will you get your housing, you will also get a capital fund for yourself. In terms of maintenance, I talked a little bit about the amount that's very much going to depend on your own circumstances. But the other question that's generally asked is, how long will maintenance be paid for? That's a question where the law is very much in a state of flux. Some years ago, we would be always looking for what's known as a joint lives order. So until either party dies, and then we'd have triggers where it would end before. For example, cohabitation after a period, say, of 6 months, the youngest child of the family being 18, but it automatically stops if a party remarriages. Sorry, if the party receiving the payments remarries.
Yeah.
Maintenance comes to an end. So we always negotiate over the term of when the maintenance ends. And then we negotiate over whether the term will be a definitive term, which can't be extended, or a term that can be extended if the circumstances require it. So every case is looked at on its individual basis.
Sure. All right, it's really helpful, and obviously, you know, we could talk for hours, but I do have quite a few questions, if that's okay, which have come in. Most of them are anonymously from women on our Facebook group, which, you know, for obvious reasons you'll understand. So I'm just going to get the first one up. So this lady is saying, please could you ask how one finds out about where the money is, if there are any hidden accounts, savings, etc., and how to find them?
I love that question because that's my job every day.
I wish my husband had some hidden accounts.
Right, so when we do the financial disclosure, it's generally begun in what's known as the court-prescribed financial statement called a Form E. And anybody who's watching will, if they're going through this process, will have seen the Form E. It's a very comprehensive form to complete. Yeah. And each party has to complete it. And it sets out basically a full financial picture of the other person's finances. So I'm going to assume that our question is from the wife, yeah, wanting to know about her husband's finances. So the first thing we would do is we'd look at his Form E. And in that Form E, he'd list his bank accounts, he'd list his investments, his savings, his business interests, his employment income, any trusts, any liabilities, a complete picture. And then we would review that. And in terms of looking for missing accounts, there's the sort of the low-hanging fruit that we can find, which is you look in the bank statements and you see if there's any transfers or credits, like payments out or payments in from bank accounts that aren't listed already. So is there a missing account?
Right. We
also say, what do you know about your husband's finances, to see if it all tallies up. So once we've got the Form E, we very carefully go through it, and then we work out what questions need to be asked. And then we ask all the questions and further documents that are needed. And the Form E requires the parties to provide their bank statements for the last 12 months. So that's the beginning, and if necessary, we can go back longer. So we're not just looking at a snapshot on the day the advice is given. We're looking at a period of time before of a minimum of 1 year. And sometimes when we start going through the disclosure, things unravel. Yeah. We can also look at if we've got property addresses or property addresses that we think we know of. We can go to the land registry and get what's known as office copy entries, which shows us who owns the property that we think he may have an interest in. Sure. So there are many ways of trying to work out and find out if there are assets missing. And we generally get to the bottom of it. And nowadays, because it's harder to launder money, hide money, and there's much more obligation to disclose what you have just generally in life, and there's less cash around than there was before, it's often easier to find out what there is. And generally, we piece it together. it's collaborative working, it's client and their lawyer working together.
Sure. Okay, that's really helpful, Neil. The next question I've got from you is from a member of the Facebook group. Says, post-divorce and receiving spousal maintenance, unless I remarry or one of us dies, or if I cohabit with, or if I cohabit could be reviewed. If he passes away, can I try and obtain some money from his estate? He pled poverty during the trial and is in business with two brothers, so they very easily hid assets, and I didn't have the money or energy to fight him. Apparently her bill came to over £100,000 and he was ordered to pay for some of it. Also, every month he's supposed to have set up a standing order to pay her, but the last few months she's had to text him to ask him to pay, which is his way of controlling her even now, she says. So what the question is what can be done about this? And also the maintenance amount has remained the same, and she's sure it's supposed to be reviewed and increased from time to time.
Right, so we've got a number of questions there. Let's deal with, firstly, standing order. If the financial remedy order said that he should pay by standing order and he hasn't set up a standing order, that's one of the points that she can enforce through the court. You can apply for a general enforcement order. In fact, the starting point, we don't want to go to court, we want to resolve everything. So dealing with that head on, she could write to him or get her lawyer to write to him and say, there's an obligation under the order to pay by standing order, you're not paying by standing order, and the payments are late. Either you set up the standing order straight away, confirm that's done, otherwise I'm going to apply to the court to enforce that part of the order. Mm-hmm. That'll wake him up and that should get him to pay, because he's got to comply with what was in the order. The second thing is, when it was said that the maintenance is supposed to go up and it hasn't been, I'm assuming, because that's all I can for the moment, I'm assuming that there was an annual increase in accordance with inflation, whether that's CPI, Consumer Price Index, or RPI, Retail Price Index. RPI includes mortgage rate, CPI doesn't. But in any event, that's generally the inflationary index we're referring to. If he hasn't complied with that, that's another thing to add to the list. Either you pay it, the increased amount, and that can be, the lawyers generally have the figures, or you can find the figures on the internet, or generally the internet or the lawyers to tell you what the inflationary rate should be in order to calculate what the increase should be. And again, if he doesn't increase, it can go back to court. The question was, if, I'm going to construct it this way, if the payment is still in place and the husband passed, or the ex-husband passed away, does she have a claim against his estate? Yes, she does. And that would have been left in the financial remedy order. As to whether or not the amount has been calculated with reference to the right level of income, because she said, I think that he's working with his brothers and she's not sure that they're disclosing the right income. I don't know what scrutiny was done when the arrangement was agreed or determined at court. If she felt that he's underplaying his income, then she might need to revisit the maintenance, and that's a much bigger question. Yeah. Bearing in mind that we're looking at all the other questions and points to raise. So that might mean a full reinvestigation of the finances to get an increase in maintenance, but that may be hard depending on how long it's been and how his income is shown.
Okay, that's very helpful. Thank you. We've got, we're quite short on time, but I'm going to ask a couple more questions if that's okay before we wrap up. This is a lady who's saying, her daughter's husband has told her he wants a divorce. She's now decided she does too, but doesn't want to spend thousands to do it. They don't have children. Their flat is in his name, but they've lived there together for 12 years and they've been married for 9. Is there a way to divorce amicably and relatively inexpensively? If so, how? And also, can you recommend what an average fee is for a good divorce lawyer? She's based in London.
Okay, so there's a number of questions there. Let's take the first one. So having decided she wants or accepts that the marriage is over and they both want a divorce, then they should start off amicably by trying to agree the basis of a divorce petition, as I said before. In terms of the property in which they've lived, it's in his name, but they've been married for, I think you said, 9 years and lived there for 12 years. When we're looking at I mentioned before the length of the marriage. The courts look at cohabitation. So if you've been cohabiting and then seamlessly you enter marriage, we look at not just the length of the marriage, but the length of the relationship. And here you said they'd lived together for 12 years. So we're looking at a 12-year relationship. The family home, and that's what it is, the property in which the married couple live together, is treated as a very special asset. And the starting point is that the equity in that property should be divided equally. That's only the starting point. I don't have all the other details, but she's definitely got an interest in the home. It doesn't matter that it's just in his name and not hers. And what she should do, if she's worried about anything, she should apply, again, via a lawyer, and we'll come on to the cost of a lawyer in a minute. She can apply to the land registry to register an interest in the property as a spouse, Homes Act notice, to stop him dealing with the property during the course of the divorce. And generally that is a step that is taken and should be taken to protect her interest. In terms of a good divorce lawyer, what are the fees? It very much depends on the experience and where they're based and their reputation. And you could go anywhere from £200 an hour to £500, £600, £700, £800 an hour. But typically in London, you might be looking at anything between £250, depending on experience, to maybe £500. But it depends. There's horses for courses. Sometimes you go and see a more senior lawyer, and then it's a case that can be dealt with by a more junior lawyer at a cheaper price. Yeah. And in terms of cost estimates, it really depends on what's involved in the case.
Okay, thank you. This next one is fairly straightforward. We've just got divorced and we share care of the kids 50-50. Dad is paying child maintenance and I'm claiming, amongst other things, child benefit. Who is responsible for things like the purchase of school uniform? That's quite specific. Typically, when the child maintenance is being paid, did you say it's being paid through the child support agency or by agreement, or does it not say? It just says the dad's paying child maintenance and the mum is claiming child benefit.
Right, so the child maintenance is generally expected to cover all the expenses that the children incurs. Mm-hmm. So that means everything. It's not untypical to try and negotiate or discuss an arrangement whereby, depending on the level of child maintenance that's being paid, that in addition, the one-offs like school uniforms and the like are additional extras that are paid on top. But there isn't a formula, so it will vary from case to case. And there are many cases where the payment is sufficient to cover everything.
Sure.
There's a child benefit.
Yeah, go on.
Just to say, the child benefit, if the children are living most of the time with her, then the child benefit would be that person's child benefit to keep. That's additional for them.
Okay, that's additional. Okay. There's a lady on the, I'm not sure if she wants to be anonymous, but she's written on the Facebook group now, so I'll read it out. Hi, we've been separated for 3 years and have sorted finances, but are not yet divorced. Is it best to apply now or wait till the new system comes in the autumn?
Well, bearing in mind that they can divorce on the basis of 2 years separation with consent, they could do it now. And if they're getting on well now, then there's no time like the present. They're better off doing it now because there'd be no advantage to them by waiting until the autumn. 2 years separation will avoid any contentious issues between them. That is already our sort of default non-fault divorce. Mm-hmm. Can I add my own question and answer very quickly, because it's really important for everyone. Yeah. When I'm doing the LBC phone-in, we get so many calls about people who have sorted out their divorces, but haven't sorted out their financial arrangements. And it is so important that you make sure you get your finances sorted at the same time you're dealing with the divorce. And so often you shouldn't apply for a decree absolute until the financial arrangements have been sorted. For example, a wife who's been at home for many years agrees to sort out the divorce, doesn't sort out her finances, so she gets a decree absolute, the finances are still live. She can still bring a claim, she can still seek to recover what she should have done, but for example, her pension claims will no longer exist because you can only have a pension sharing order within the, if it's made during the marriage.
Mm-hmm.
That's why we don't want the decree absolute if we haven't had a pension sharing order dealt with. And another point I've just remembered that I should add is when I was talking about sharing capital and receiving maintenance, there's also pension sharing claims. Pensions are an asset like anything else, and they need to be taken into account. And quite often we need pension experts to advise on how best to share the pensions, because you can't just look at the amount that's in the pension, it's also what the pension will produce.
Right. Oh, all right. I'm going to ask one more question, but just very quickly before I do, because we do get a lot of women asking advice on the Facebook group, and one recurring theme is, that, for example, the husband has literally just announced he wants a separation and divorce, and it's come perhaps as a massive shock to the wife. If it's not amicable, it's almost like kind of, okay, now what? Is it, if he's not willing to discuss anything and sort of goes, perhaps just goes quiet and he goes off and just tries to deal with it himself, is there someone in between a lawyer and, say, a mediator, without having to pay huge amounts of sums, just to help that woman get, almost get your head together and think, okay, what do I do now?
There are various different options. There are Mackenzie friends who are non-paid, they're not in the same way qualified as us lawyers, but have amazing experience and can help to advise those who need help, who can't necessarily afford, a full-blown lawyer. Mm-hmm. And some of those Mackenzie friends are amazing and can provide great assistance. It all depends about cooperation, because if you've got an element of cooperation, you can say to your husband, can we go and see a mediator and try and work out, let's get a framework for those things that we need to deal with. So we need to deal with the divorce, we need to deal with the finances, we need to deal with the children. Yeah. And get a framework as how to work with that. And then the mediator is not advising either party. The mediator is there to try and facilitate agreement. Yeah, okay. And you can still have a lawyer, or if the mediation works and you get a settlement, you can then take that to the lawyer or lawyers, because one lawyer cannot act for both parties, in order to draw up the agreement and get everything filed with the court. So it's a lawyer, a mediator. And the other thing I'm a great advocate of is therapists. The right therapist can be fantastic. I often regard myself as a life coach, so I do that bit of therapy, but I'm not a qualified therapist. I've just got years of experience of doing this job, which I love. But there are therapists who are fantastic at helping people, and that often means helping them in making the decisions. Do they want a divorce? Do they not want a divorce? Helping people to gain self-confidence and learn that you can't always control how someone else behaves towards you, but what you can do is control how you react. And that's not always sometimes giving in, allowing someone else to control you. And what we try and do when I'm advising is try and recreate a more level playing field. Sure. Therapists can do that as well.
Sure. And there's Rights of Women, which is a website's on our helplines page as well, for any women who, we talk about, abuse, but there is the controlling element of a divorce process, which, is often, it's classed as emotional abuse. And Rights of Women is a very helpful organisation, which, we're quite keen to get out the word about.
I would heavily support that. There's a huge sense of vulnerability, quite often just in everyday life. And when there's then the potential exposure of a divorce, that vulnerability magnifies to the nth degree. People need support. I could go on all day. I mean, I just love advising and helping people. But the other thing is, we lawyers are not doctors. Sometimes clients need medical help. Some clients, I know from experience, they're scared of going on antidepressants. And please, I'm not advertising antidepressants or saying they're great. Some people need some help. There's just too much to cope with. But they're worried about, will it mean that they're not considered fit enough to look after their children? If I had £1 for every time I had been asked that question, I could make a huge contribution to children's charities. The real issue there is if you need help, get help, because you're a better mother if you take the help that you need, and it will not be held against you in the slightest, because you have no idea how many people are on antidepressants because they need it, and doctors or otherwise therapy. But you should be liaising with your GP. I often say to my clients, let's get a help from your GP or another doctor, unfortunately, because of the NHS backlogs at the moment, sometimes from private doctors and private therapists. We're a multidisciplinary face these days, and we have to use all the other resources available.
Yeah, and I think that's what our platform is all about, supporting the woman in the middle. And often, sadly, we're going through things like menopause and health problems at the same time that all these other pressures sort of come crashing together. And so, we always sort of say, make sure that whether it's your hormones or your health is sorted, so that you're, in the best possible shape to then deal with this situation as well. And obviously we're all living through this horrendous pandemic, so we're living on top of each other 24/7, and even the strongest of marriages are sort of cracking at the seams right now. So look, Neil, it's been so helpful having you on here, and we've got loads of lovely messages of thanks on the Facebook group too. What I'm going to do, everyone, is we're recording this and we're going to embed it in the blog that Neil has written for us, and it'll be on our YouTube channel and on our website, which we'll share on all our socials. And if anyone has any more questions, please email me, katie@lattelounge.co, and I will forward them on to Neil for hopefully some generic signposting. And as I said before, check out us on Facebook, the Latte Lounge, top tips for women over 40, Instagram @Lounge the Latte, Twitter @Lounge_Latte, and lattelounge.co website, where there are lots of midlife resources, and Neil's website, I should say, Neil's blog. Lastly, Neil, just tell everyone where they can get hold of you. Obviously, you're in our directory on our website, but if anybody would like, a private appointment with you, who should they contact?
Okay, if my secretary, my PA's been with me 21 years, would hear this, she goes mad, because I like to deal with my diary myself. I'm always flexible as I can and seeing people, particularly for that initial advice. The easiest thing to do is either email me if they go to the website, the Seddons website, and they put in Neil Russell on the profile, they'll find me and they can email me, or they can ring me on my office number 0207 020-7725-8014. And then if a client becomes a client, I'll give them my mobile number as well. And I'm generally very accessible. So email me, neil.russell@seddons.co.uk, or ring me on my direct line, and I'd be happy to. Can I just, forgive me, say about the disclaimer again, any advice that you've heard today is generic, it's not specific. It can't be relied upon. It can only be relied upon if I'm actually acting for you, because I don't have all the facts. And I wish everybody luck with the advice I've given. And if I can be of any more help, I would be delighted to be able to help.
Lovely. All right. Well, thank you very much, Neil. And thank you, everyone, for joining us. And we will share this on the Facebook group later on today. So have a good day, everyone.